Hi friends, let me introduce myself, Advocate Shahid Ali Ansari, practicing lawyer at High Court, Bombay. Today I would like to discuss with you some of the important and pivotal judgment of the Honorable Supreme Court of India as well as one Honorable High Court of Punjab and Haryana. These three judgments are related with the bail. As we know that under section 437 of CRPC, we can move the Honorable JMFC Court for filing regular bail applications, and under section 439 of CRPC we can approach the Sessions Court as well as the High Court for filing regular bail applications. And we know that there are some factors which need to be considered while deciding the bail applications. Some of the important factors are that whether the charge sheet has been filed or not, as the investigation is going on. In such a cases, sometimes the court does not grant the bail. Number two, whether the accused has criminal incidents or not. If he is habitual and has committed so many offences and he is in the habit of committing similar kind of offences, in such a cases, the Honorable Court rejects the bail. Chances of accused tampering of the evidences as well as the threatening to the prosecution witnesses. This is also one of the important factors. And again, one of the factor is that whether accused is likely to run away, he is not likely to come in the trial. In such a cases, his bail will be rejected. As we know that in case of non-bailable offences, granting bail is the discretion of the court. It is not matter of right. However, in some cases, we are going to consider one of the factor that in cases of offenses pertaining to the cheating and forgery, if amount is involved, like if a person has purchased the materials or any got the services from the other side and has not paid the amount, or breach of trust, or misappropriation of amount, or forgery, etc. In such a cases, court puts a condition, that is court may direct the accused to deposit the amount. Then and then only court considers to grant whether to grant the bail or not. For example, if a person has cheated for rupees 1 crore to Y, in that case, if accused is ready to deposit amount 1 crore rupees, in that case court may consider such a thing factor and court may grant the bail. However, we are going to discuss the three judgments pertaining to this aspect only, whether in bail applications, whether regular bail application or in anticipated bail application, whether court can put a conditions to accused directing him to deposit the alleged amount of cheating, whether such a putting such a condition by the court is valid or not. So we are going to discuss three judgments. One significant judgment of the Honorable Supreme Court of India is Uddhav Thakur and another versus State of Jharkhand. This judgment is delivered by the Supreme Court in Criminal Appeal number 1703 1704 of 2022. In this case, the Honorable Supreme Court said that while deciding the bail applications, the court is not working or acting as recovery agent. Therefore, the condition that court is putting directing the accused to deposit the amount is not valid, and such a condition cannot be put because in the view of the Supreme Court, court is not working as a recovery agent. Therefore, court cannot direct the accused to deposit the entire amount of the fraud or alleged crime so as to grant the bail. Therefore, such a condition cannot be put by the court, as court is not working as a recovery agent, or this is a bail application pertaining to the liberty of the accused under Article 21 of the Constitution of India. Therefore, it is not a recovery proceeding. Furthermore, bail is a pre-trial, it's an application and it's not trial. Therefore, if the court puts a condition directing the accused to deposit the entire amount of alleged fraud, for example, X person has committed a crime and he cheated to Y to the extent of 1 crore rupees. If court is putting condition to deposit the amount of 1 crore while deciding the bail application, then what remains in the trial? Nothing remains in the trial. Therefore, in the judgment of Udho Thakur and another versus State of Jharkhand, delivered by the Supreme Court, which I'm also like would be giving the name title in the comment box. You can write down the name of the judgment Udho Thakur versus and another versus State of Jharkhand. In this case, the Honorable Supreme Court in Appeal number 1703 and 1704 has laid down a law that while deciding the bail application, the court cannot put a conditions to the accused directing him to deposit the alleged amount of the fraud so as to grant the bail, because court is not working as a recovery agent in this case and no such a condition can be put. This is one of the judgments. And again another judgment of Dilip Singh versus State of Madhya Pradesh. This judgment is delivered by the Honorable Supreme Court in the year of 2021. In this judgment also, the same thing was told by the Honorable Supreme Court, that the fact of the case where that a director has misappropriated the amount of 41 lakhs and another director has filed a case against him. In that case, the Honorable High Court of Madhya Pradesh put a conditions directing him to deposit 41 lakh rupees for granting the bail, and that bail application was rejected because he did not deposit the same amount. Later on, the accused moved to the Honorable Supreme Court, and Supreme Court has said that no precondition for deposit of alleged cheated amount can be imposed, nor can bail petition be converted into recovery proceeding. That is the important line. Because this is not a recovery proceedings, so no such a condition can be imposed in a bail for granting the bail, because it is not recovery proceedings, and such a bail application cannot be given the color of recovery proceeding or cannot be converted into legal recovery proceeding, etc. So same thing has been stated in this judgment also, that is Dilip Singh versus State of Madhya Pradesh. Dilip Singh versus State of Madhya Pradesh, that no such a condition could be put by the court directing the accused to deposit the amount for the purpose of granting the bail. If such a condition is put, then it is not valid. Again, these are the two judgments of the Supreme Court. Now, there is also one judgment recently given by the Honorable High Court of Punjab and Haryana. The same thing what is stated in these two previous judgment, what I told in this lecture, has been reiterated by the Honorable High Court of Punjab and Haryana in Arun Bhardwaj versus State of Punjab. In this case, the High Court of Punjab and Haryana has also repeated the same thing and said that no condition could be put by the court directing the accused to deposit the amount of alleged crime or forgery or misappropriation, etc., so as to grant the bail, because this is not the recovery proceedings and the bail application cannot be converted into a recovery proceedings. So these three judgments are very much important from the viewpoint of advocates while arguing the regular bail applications or anticipatory bail applications. You may use these three citations, which I'm also putting the name of the same and title of the same in the comment box. And these judgments are very much important for the purpose of argument in respect of the bail matters. We know that prior to this, there was a judgment in the year of 2014, that is Subrato Rai versus State. In that case, the Honorable Supreme Court said that and directed him to deposit the remaining amount, deposit the alleged amount, etc. If the said amount was not deposited, then court has cancelled the same. So such kind of judgments are exceptionally given when the amount involved in the crime is belonging to the public, or like a fraud is committed in the bank, or public at large has been cheated by the accused. In such a cases, court may put such a conditions to the accused to directing him to deposit the amount. However, in these three judgments which I have spoken about, these three judgments, the law is that no such a conditions can be put directing the accused to deposit the amount. In such a bail applications, such a condition cannot be put. It is not recovery proceedings. Hope that you have understood and hope that you are going to utilize the same three judgments while arguing the bail applications. Thanks for hearing to me.